want to talk about a writ of Quaranto. Warranto. Writ of Quaranto. This is a pretty powerful remedy when you want to find out exactly what officer, public officer is actually, by what authority they're trying to exercise their power or said authority. Okay, I'm gonna read up on this here, so we're gonna get off into this here. I'm gonna start off with this. This is here the Georgia Code, of course, Title 9, Chapter 6, Article 4. Okay, for what purpose? For what purpose a Quaranto may be issued? Okay, who may bring an action? So a writ of Quaranto may issue to inquire into the right of any person to any public office and duties of which he is in fact discharging. It may be granted only after the application by some person either claiming the office or interested in. Okay, and they have to grant it after you issue the writ of it. You know what I'm saying? The writ is actually the command. Keep in mind that's what a demand for something. Matter of fact, let me so you understand what I mean by that. See, a writ is an order issued by a legal authority, with administrative or judicial powers, typically a court. Okay, typically a court. Okay, so writ says now you can actually. Okay, let's go back to that. Hold up, I'm in the wrong spot. So writ of Quaranto may be issued. Okay, it's an order. It's an order that basically where you're ordering a public official to actually how can I say, bring forth the information, the proof, the evidence to prove exactly where they get their authority from. That's the order itself. Okay. It may be granted only after the application by a person, either by some person either claiming the office or interested therein. That's the one that has to grant it, the one that you actually inquiring the information from. Okay, let me go to the next one. Here we go. The writ of Quaranto may be granted at any time on proper showing made. Any person saying any issue of fact made thereon must be tried in equity cases as an equity case. Okay, this is dealing with living men and women. Y'all know that. We're not dealing with this. It's like in your private capacity, in your not in your straw man status. I would be issuing one of those. Like if I was to file a inquiry on say a writ of Quaranto, like I'm trying to say, for instance, you don't know where the judge's oath of office is located. You don't know where it is. You've looked for it. Nobody actually, they don't have one on file. You want to know, okay, where the hell you get your authority from? How do you even get on this case? When I can't find any information proving that you have any authority to be even sitting in that spot. You don't even have an oath on file. How are you in office as a judge? Then you might want to inquire about his authority in the first place. That's where this would come in at. That's where this would come in at. They would, you need one of these here ordered to, given to him. He needs one of these so he can show exactly where the hell he get his authority from. Okay, let's see. Here we go. Let me go back to this here 60 right here, because it has some good information down here at the bottom. Common law origin. See, common law origin. It says the ancient common law writ of Quo Warranto was a writ of right by the crown, as was used to prevent the usurpation of an officer or franchise. Okay, you know what a usurpation is? I don't know if y'all know what that means. so y'all know. I'm gonna show you what it means instead of just telling you. I don't like telling y'all stuff and not showing you what it means. Oh hell, how you gonna use the same damn word? Let me see. We're gonna use usurp so you understand that. To seize and hold as an office, place, or powers in possession by force without right. So somebody just pretty much trying to debo some authority. That's basically what that is. So you see what usurpation is. To prevent the usurpation of an officer or franchise. That's what it's used for. Ancient Writ of Quo Warranto has been materially modified by statute. There no longer exists a writ of right, but a prerequisite to the maintenance of an information in the nature of the Quaranto is leave of the court, granted on application therefore on the exercise of a sound discretion to file the proposed information. In action seeking a writ of Quo Warranto is one of the specific statutory proceeding subject to the Civil Practice Act. Let's see, I'm gonna have to bookmark this here and see what I can find with that, just to kind of see what they're talking about with that. I'm just bookmarking that for myself, y'all, just for myself. Let's see. This section expressly denies writ of Quo Warranto to person. It expressly denies writ of Quo Warranto to a person who is not either claiming office or interested therein. So you ain't gonna just bring it to anybody. If they pretending to be a judge, they pretending to be this, pretending to be that. As a public officer, then you have the right to actually send that to them. They have to prove exactly where they get their authority from. Under this code right here, writ of Quo Warranto applied only where right of any person to public office was involved, and in formal code, the remedy applies where civil officers were concerned. Public office within meaning of this section means office which has been lawfully created by the Constitution, by some statute, or by municipal ordinance passed in pursuance of legislative authority. And these are case laws. Y'all see, right? You can actually look these up. These are case laws. That's what these come from. Let's see. Y'all can tell this early in the morning. I'm talking a little lower than usual because I ain't trying to be too loud. It's like, what, 4 in the morning? It's actually 5 in the morning. I came back here about 4:30, started messing around, and I got started. Okay, public offices right, authority, or duty conferred by law, by which an individual is invested with some portion of the sovereign functions of the government to be exercised by the individual for the benefit of the public. The warrant to exercise powers is conferred not by contract but by the law. It finds its source and limitations in some act of expression of the governmental power. The term public office embraces ideas of tenure, of a duration or continuance, but it is held that these elements are not essential where other qualifications of officers are present. Public employments are public offices. Okay, notwithstanding the instability of the tenure by which the incumbent holds. Okay, and this is pretty much. Let me see right here. Got a good idea of what a public office is now, y'all. A public office is. Let's see. Private entities appointed by the. I'm gonna read this one right here. Quo Warranto denied challenging appointment of judges. Trial courts denied denial of the challenger's petition for writ of Quaranto was affirmed because the newly created position of the Georgia Court of Appeals qualified as vacancies under Georgia Constitution. Okay, we don't need that part. Let's see. Writ of Quaranto as to private entities appointment of board of ethics members. Let's see. Trial court correctly granted the writ of Quaranto as to the fourth challenge members appointed to the county board of ethics by private entities as those appointments were unconstitutional as the private entities did not answer to the people as required by Georgia Constitution and were therefore not authorized to wield the power to appoint public officials to the board. Okay. Okay. I think do I have to keep going with that part? Let's see. I think I already read on this page what I needed to read, what I wanted to share anyway. Let's see. Remedy applies to the civil officers of this state except governor. Yeah, I did see. I saw this here, right here. Say it doesn't apply to except the governor. It doesn't apply to the governor. Say I saw that written on the California one too. Say you can't, try to get a writ of Quaranto on the governor. Say it doesn't apply. It said that in California as well. I suppose they wouldn't become the governor except probably through the president. I have to look into how they get in office, but I've never looked into that part. Let me go back up here. Let me see, where am I? 60, 61. I looked at 61 already. Governor exempt. When granted, a writ of Quaranto may be granted at any time on proper showing made. Any issue of fact made thereon must be tried as an equity case. I think I read that already. It's dealing with men and women, living people. It's an equity case. So that's not. Let's see. Service of process. We already know this is actually done the same way you do it in any other service of process. Let's see how issues of determining law application. Let's see. That's just talking about the whole process itself. You have to make sure y'all look inside your state statutes to see exactly what if yours is different from Georgia on how you actually issue them out to people. You know what I'm saying? Issue those warrants, the writ of Quarantos out to the people. I want to share with y'all what it says in the Black's Law Dictionary about Quaranto. In old English practice, the writ of a writ in the nature of a writ of right for the king, against who claim to usurp any office, franchise, or liberty to inquire. Remember, we just looked up the word usurp. By what authority he supported his claim. In order to determine the right. It lay also in case of non-user or long neglect neglect of a franchise or misuse or abuse of it. Say being a writ commanding the defendant, that's the one who's actually being ordered to do so, to show by what warrant he exercises such franchise, having never had any granted of it, say, or having forfeited it by neglect or abuse. Okay. The judges on it's a judge on my case is sitting there. The case been going on for like 3 years now, and it's just been sitting there. And I've been having a problem finding this man's oath. And I called him on his phone last week. And I asked him about, where's his oath? And he claimed to not know where it's located. Keep in mind, he was put on this case 3 years ago. Makes me wonder, does he have an oath at all now? Because he's still sitting on this damn case. And he claims to not know where his own oath is being stored. And I went to called his county, the county where he was actually originally at, where he was really originally located. And they say he hasn't served in that office in a few years now, because he's a senior judge now. And, he's been in the game damn near 30 years now. And he hadn't served in that location in a few years. So I'm like, So that's when maybe go to the Bar Association, to the website to look him up. And I found his contact information, called the number. The number happened to be his cell phone number. So he's the one that answered the phone. And that's how he is. He's the one that told me that he don't know where his oath is located. And so, but he told me that he was, I find that kind of fishy that you don't even know where your damn oath is housed, and you've been in the game for damn near 30 years and don't know. Not saying that can't be possible, because some people just kind of not worry about where it's at. They just kind of following the procedure in order to walk in their office, and they leave that up to the ones that's responsible for housing the oath. And he's on the other things. I don't know, but we will be finding out. So that's what made me kind of look into this particular topic right here. I think this would be what I'm gonna have to use in order to find out where the hell is your damn oath. By what authority are you standing on this court case? Because if I can't get no remedy from a court case, by someone who's just sitting on a court case and he's not properly equipped with the requirements, that's required by law for him to even be sitting in that office and presiding over a court case. So how do I get the remedy from someone who don't have the authority to do it in the first place? So anyway, we're gonna find out. I thought I'd just kind of throw that out there so you get a good idea of what this, what I'm looking at, what I'm thinking when I'm looking at this topic right here. An extraordinary proceeding, prerogative in nature, addressed to, these are case laws that y'all see I'm reading right here. Addressed to preventing the continued exercise of authority unlawfully asserted. See, that's what I'm talking about here. You got people that are practicing law from the bench, entering in, they basically pretending like they have authority that they don't have. When I was in my child support case, I've seen, not even just my case, I've seen, I've watched video footage of people doing Zoom child support cases and custody cases, whatever. But people have shared with me that they did themselves. They screen recorded themselves. Where this one lady, as a matter of fact, I'm going to speak about this one guy. Y'all know about my case already. It's this guy, his name was Marcus. I was helping him out. He was trying to get custody of his daughter. And, that was a different topic because it was a whole obstacle he was going through trying to obtain custody of a child that he's not on the birth certificate for. So, of course, he already knew that was an uphill battle, but he thought he'd give it a try anyway. But anyway, they were trying to flip it as if he was a defendant and more so than the plaintiff. And the woman had the nerve to use, it was a female judge, and she was using an authoritative voice talking to him saying, "You will pay child support." And he was a little nervous about that situation, because she was talking like she had this authority that she didn't have. And I mean, talking this tough ass talk to this man, and that's what kind of, I guess that scares a lot of guys when they go in these court cases, when they talking when these judges go to talking that bully talk, using that bully tone to talk to people. And then that scares a lot of guys into compliance because they're thinking that if they buck on what they just said, what was just said to them, especially in such authoritative manner, they just bend over and take it out of fear. And they're thinking that if they say they object at all, they'll go to jail and sit like that. And I've had that happen to me before too in a court case. I'll finish letting a judge talk, but I'll object when they're done talking. because I'm not, I'm one of those. Hell, my folks will come get me out of jail, so I'm gonna chance it. That was just that's just how I saw that, and I'm just like, cause I know what I was saying was correct, and I know that nobody can bully me into just telling me how I'm gonna raise my child. That's my baby, and so I'm not fearful. I can't act like I didn't feel no type of fear in that situation. But the thing is, even when I'm feeling that, I'm not gonna fold like that. I'd rather go down fighting. Because if I know some shit is not right, I'm not gonna bend over and just let somebody just bully me into telling me what I'm gonna do on how I'm gonna raise my offspring. I'm just not gonna do that. I don't know. I'm just not wired like that. So, but I did have to understand that it's a chance, a time to speak. You can't cut them off. Don't loud mouth them. You gotta keep order, keep yourself, keep your tone down. You don't have to sound like you're trying to fight nobody. You ain't got to be belligerent. You ain't got to call them out their name. You don't have to be disrespectful. You can, you just have to stand on it. Stand on what it is that you believe in. I'm trying to stay on topic, but I'm just telling y'all, when you're running these officers, a lot of times you in court and they go to talking with that authoritative talk as if they have authority that they don't have. These things right here, they don't have that type of authority, but they will pretend like they do. This can even tie into what I'm talking about when I've been talking about for the past month, rebutting presumptions. And at that point, when you rebut the presumption of death, for instance, for example, they have no authority at that point. They have no authority at that point. They have no authority anyway unless you give it to them. Matter of fact, by the consent of the governed. Consent of the governed refer to the idea that a government's legitimacy and moral right to use state power is justified. Get this off of here. Anyway, I don't like to have highlighted stuff. It's justified and lawfully only when consented to or agreed to by the people over which the political power is exercised. That's the Constitution, y'all. That's the Constitution. Let me see. Let me see if I can find a little spot in there. It's in the Bill of Rights as well. Let me see. I'm trying to find something else so y'all can understand what we're talking about. Declaration of Independence. Let's see. It's in the Declaration of Independence. Wish they highlighted that so I don't have to go read this whole damn thing to show it to y'all. Let me see. Equal, created, rights defined. Where is it? Where is this all the band? I've read this before. It's in this damn thing somewhere. I don't feel like reading this whole thing right now. But it's in the Declaration of Independence. Let me see if I can find another spot. They normally highlight shit. When I want them to highlight, they won't highlight it. Cause I don't feel like doing all that. I just feel like I might just have to read it in a damn way. Let's go for it. To hell with it. This is National Archive. So y'all know this is legit because this is not National Archives. You see, it's a government website. It's speaking about the Declaration of Independence, a transcript. Unanimous declaration of the 13 United States of America. They say when the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and the laws of God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be evident, self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. That among these are life, liberty, and pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That's what I was looking for. That's where they get their power from. Your consent. They don't get to just debo your ass into no damn contracts. They don't get to debo you on how to raise your kids. They don't get to debo you in no kind of damn way. You have to but if you're operating as a legal fiction, if you're operating as, go back to my last video that I posted just about a day or two ago when I was talking about, what did I name that video? I'll be forgetting what I be naming my videos. I'm gonna tell y'all in a second. I'm looking on my stuff now. The last video I just posted, it was about assumed dead probate power. That was it. Go back and look at that video and come back and watch this video again. You'll see what I'm talking about. Your name in all capitalized letters. You operate as a dead fiction. They're gonna control you because they are trustees of that Sestake trust. And here you are operating as someone that's not even alive. Okay, but when you're operating as a living man, living woman, they have to have your consent to do this type of stuff. Child support, they have to have your consent to do that. Okay, that's why you have to speak up. You have to be willing to stand on that shit. It goes back to the Writ of Quo Warranto. They have the power to adjudicate the case, but you have to know who you are when it comes to these court cases. If you don't know who you are, they're gonna bend you over. It's just that simple. They're gonna bend you over. So, here we go. What was I? Legal definition. I already showed y'all that. Damn. So that's pretty much it. I think that's all I'm gonna show for tonight. For this video, we're at 27 minutes already. So yeah, I guess I'm gonna stop right there. But I wanted to close in that so y'all understand. Was I done with this? Then let me finish reading this little part. Let me see what else. I think I showed y'all most of this. Let's see. The Writ of Quo Warranto belongs to the state. It is in its sovereign capacity to protect the interests of the people as a whole and guard the public affairs. And it is a preventative remedy addressed to preventing a continued exercise of authority unlawfully asserted, rather than to correcting what has already been done under that authority. And that is the case law for that. Quo Warranto is a legal action whereby legality of exercise of powers by municipal corporation may be placed in issue. Okay, that's the case law for that. The federal rules are applicable to proceedings for Quo Warranto to the extent that the practice in such proceedings is not set forth in statutes of the United States and has heretofore conformed to the practice in civil actions. Okay. In remedy that could have been obtained under the historic writ of Quo Warranto may be obtained by a civil action of that nature. Okay. In case I can stop right there, but I just had to let me see. It was another spot I wanted to show y'all, and I think that thing said the same thing. This is that was 1933. I just clicked on and showed y'all. I think that was, and this is going to be 1968. Both of them are Black's Law Dictionary, as you can see in the top of your screen. And this was saying the same thing, but I wanted to also read this part, which says the exact same thing. I just wanted to kind of let y'all see. kind of put it in y'all head about understanding exactly what it is about. It's basically you're inferring. You basically it's intended to prevent the exercise of power that's not conferred by law and is not ordinarily available to regulate the manner of exercising such powers. So if someone's exercising, they usurping authority, pretending they have authority that they don't damn have, then you can actually use this against them. Okay, because they are limited. They don't. I hear a lot of people, they quick to say that these people do what they want to do. They just do what they want to do. They ignore the paperwork. They ignore this. They ignore that. First and foremost, you have to be willing to check yourself about what you're doing, how your paperwork is worded, how you articulating your stuff. Are you just making up some shit as you go? Are you just trying some shit and wondering why shit is not working? Are you using somebody's somebody on the internet's strategy that they done sold you, some process you done bought that they can't even prove actually is even applicable in any court case? Be mindful about that, y'all. You try something like that and then it don't work, and then you can't always blame it on the officials when you buying shit off the internet that you don't even know why you even doing it. So got to be willing to check yourself first, and then you check the authorities if they're just railroading you, and you know you've actually studied this out, and you actually know what you're doing, and you know they're actually just breaking the law because you've read it in the laws. You know what you know for a fact because you read it, not because somebody told you something. Then you know, here you go. This is where you jump, exercise this stuff right here. You exercise this stuff, but be mindful. A lot of these judges knows, and a lot of times I even have to check myself. A lot of times I don't be getting the shit right. Sometimes I had to learn it over the years. I didn't get it right sometimes. Like for instance, I got a confession myself with my writ of habeas corpus case. I filed all the stuff I sent to that judge. I sent it to him. I didn't file it in the court case. Now here it is a month later. I haven't heard anything. He didn't do shit. Okay, so I can't blame him for not moving like he's supposed to move because I didn't file what I gave him. I didn't file it in the case. So now I got to go gather up all my shit all over again. Everything I gave him and send it to him. I need to, because of course I read it in the laws. It didn't say I had to send it to her. It didn't say I had to, it didn't say I had to send anything to her. It said I had to send it, to the judge. But I still should have known to put the shit in the damn court case. I did know. I really was just trying some shit to see how it would go. So, I ain't mad at the judge for not moving. You know what I'm saying? So the thing is, I got to make sure I file the shit in the court case, get file stamp copies, send it to him so he know that it's filed in the court case. That way we can move forward. You know what I'm saying? So these are the things you have to understand. You have to be willing to check yourself and how you're doing processes. There's another guy I spoke with just the other day. He filed something in a court case that was it was a document that he created in Georgia, but he didn't get it. He didn't get it apostilled so that he can use it in another state. He just used it and he filed it in a court case in a totally different state and wonder why he's still getting railroaded. And he was saying the same thing, that they was just doing what they want to do. I'm like, no, bro, you gotta do it properly, man. You can't just file it in the court case and it was something that's created in another state. That's a totally different jurisdiction. We don't know who those people are. They real notaries. We don't know if they're real notaries. Anybody can get a notary stamp created. So that's the purpose for getting things authenticated. And when you're using something right here within the states, within the 50 states here in America, or within the jurisdiction of America, you get it apostilled, authenticated. You want to use it in another country that's not affiliated. Like that's why y'all talk about the Hague Convention, because that's in the jurisdiction of the United States. That's why they give you apostille instead of authentication. But if you're going to use something within another state, you want to get it, and it's created in a different state. And here you are in California, and you got something created in Georgia, and you want to use it in a court, and that's in California or any other state. You want to get that document that was created in Georgia authentic. You want to get it apostilled at the Secretary of State in Georgia. That way you can use that thing in another jurisdiction, because it's been authenticated by it's been apostilled by the Secretary of State within the state where it was created. So now they can respect it and they can be used as admissible evidence. So we got to understand the order of things too, you know, while we're actually moving in our processes too. So I thought I'd just kind of throw that out there too. So hopefully y'all got some out of this, you know, the Writ of Quo Warranto. Have an understanding of what it's for, what it's about, what its purpose, and hopefully that information that the little what I just said to you, you got some out of that as well. Because I know a lot of times we got to really be willing to. We're all still learning at the same time. We're constantly learning, and be willing to, you know, and keep your energy right, keep your minds cleared. Don't be so quick to anger. You know, be high-headed about the situation, because you won't get nowhere like that. You know, having a contentious attitude about this stuff when we're dealing with public officials or anybody else, we're not gonna get nowhere like that. Okay, so just keep calm. Learn this shit as we go, y'all, and move forward. All right, y'all. We'll holler at y'all in the next video. If you haven't liked and subscribed already, please take a moment to do so, and feel free to share these videos as much as you can. All right, help me get it out there. All right, talk to y'all later in the next video. Emerald signing out.